Welcome to this explainer on a truly landmark Supreme Court case, Nandini Satpathy versus P.L. Dani, citation, 1978, 2 SCC 424. Today, we're going to rigorously break down the actual boundaries of your right against self-incrimination. Let's just dive straight into this, because whether you're a law student analyzing constitutional shields, or really just someone fascinated by how our civil liberties hold up in the real world, this case, it's an absolute masterclass. It's all about that delicate balance between state police power and fundamental human dignity.
So let's start with a really crucial question, one that strikes right at the heart of criminal jurisprudence. When exactly does your constitutional protection actually begin? I mean, you see it in movies all the time, right? The dramatic courtroom refusal to testify. But what happens hours, days, or even weeks before that, when you're sitting in some sterile, intimidating police interrogation room? Does your right to remain silent protect you then, or does it only magically kick in once a judge is looking down at you? Well, that is the exact riddle the Supreme Court had to solve here.
To make this crystal clear, we're going to move logically through the case. We'll hit the facts of the case, the core legal issues, the rules and statutes in play, the arguments from both parties, the Supreme Court's reasoning, and finally, the ultimate judgment.
Okay, Section 1. The facts of the case. The interrogation of Nandini Satpathy.
Here is how a standard corruption investigation quickly escalated into a massive, high-stakes legal standoff. The Deputy Superintendent of Police initiated a probe against Nandini Satpathy, the former Chief Minister of Orissa, regarding wealth that was allegedly disproportionate to her known income. So the police summoned Satpathy to a vigilance office. Once she's there, they hand her this massive, highly detailed questionnaire all about her personal assets and political funding. Now, suspecting this is a trap to make her admit guilt, she simply invokes her right to remain silent and refuses to answer. But the police didn't just shrug and let her walk away. Angered by her silence, they actually filed a formal criminal complaint against her under Section 179 of the Indian Penal Code. Essentially, they charged her with a crime simply for refusing to answer a public servant.
Moving to Section 2, the core legal issues and the constitutional questions at stake.
This whole factual standoff brought three interconnected, really critical constitutional questions right to the Supreme Court. First, the temporal scope. Does Article 20, Clause 3 even apply during pretrial police interrogation or only when you're formally on trial? Second, how on earth do you harmonize the conflicting statutes at play here? And third, what does legal compulsion actually look like when you're in police custody? Does it have to be physical torture, or is the threat of jail time for staying silent enough to count as being compelled?
This brings us to Section 3, the rules and statutes, and specifically the conflicting laws.
So our absolute foundational rule here is Article 20, Clause 3 of the Constitution of India. It clearly dictates that no person accused of any offense shall be compelled to be a witness against himself. This is the ultimate shield against self-incrimination. But wait, how does this actually interact with everyday police procedures?
Well, that's where we hit this brilliant, terrible catch-22. On one hand, Section 161, Clause 2 of the Code of Criminal Procedure states you are bound to answer police questions truly, except, and this is key, questions that have a tendency to expose you to a criminal charge. So that's basically a statutory reflection of the Constitution. But on the other hand, Section 179 of the Indian Penal Code makes it a literal crime to refuse to answer an authorized public servant. So the police use Section 179 to say, look, if you don't answer, you go to jail. And Satpathy used Section 161(2) to say, yeah, but if I do answer, I might send myself to jail.
Which leads perfectly into Section 4, the arguments of the parties. The state versus Satpathy.
With these conflicting statutes colliding, both sides presented really powerful arguments. The appellant, Satpathy, argued that simply being in police custody is an imminent peril. Forcing someone to answer under the explicit threat of a Section 179 charge, that is the absolute definition of legal compulsion. But the state had some perfectly valid administrative concerns on their side. They argued that if every single suspect could just shut their mouth and yell self-incrimination, the state's ability to unearth complex financial crimes and political corruption would be completely paralyzed. They contended that constitutional protection only triggers once a formal accusation is filed in a courtroom, not during an early-stage investigation.
Section 5, the Supreme Court's reasoning. This is where civil liberties get a massive expansion.
Justice V.R. Krishna Iyer, who had a real way with words, elegantly dismantled the state's narrow interpretation. He used this famous reference to Greek mythology, noting that the law cannot force a citizen to navigate between the scylla of self-incrimination, meaning talking and admitting guilt, and the charybdis of a prosecution for silence, meaning going to jail just for keeping your mouth shut. He pointed out that if the right to silence only started at a trial, police could just use manipulation or threats to extract a devastating confession beforehand. That would render the actual trial completely pointless. Therefore, the right has to begin the moment you are targeted as a suspect.
The court also radically expanded the definition of compulsion. They ruled that compulsion isn't just physical torture or third-degree brutality. No, the sheer psychological pressure of a police station, the atmospheric coercion of being locked in an interrogation room, and, crucially, the structural threat of facing an immediate penal charge under Section 179 just for remaining silent, all of that collectively constitutes an overwhelming form of duress.
Furthermore, to make this actually operational for law enforcement, the court established the tendency to incriminate test. This is huge. It means Section 161(2) doesn't just protect you from directly confessing, like saying, "I did it." It protects you from giving any answer that could provide a link in the chain of evidence or uncover collateral facts that the prosecution could eventually use to secure a conviction.
But what's really fascinating here is the balance the court struck. You don't have total blanket immunity to just stonewall an investigation. For incriminatory questions, yes, the right to silence applies absolutely. You cannot be compelled. But for purely neutral questions, your identity, your address, basic structural facts that carry no criminal weight, you are statutorily bound to answer truly. The fear of incrimination has to be reasonable and grounded in reality, not just some arbitrary excuse to ignore the police.
Finally, Section 6, the final judgment and the preventive safeguards.
So how did they resolve this? The court allowed Satpathy's appeal and ruled that prosecuting her under Section 179 in this specific context was unconstitutional. They directed the investigating officer to go back to the drawing board and literally separate the purely neutral questions from the incriminatory ones. And, to prevent future custodial overreach, they instituted a massive, game-changing safeguard. They granted her the right to have her lawyer present during future interrogation sessions. This firmly established the right to silence as an unshakable pillar governing all police investigations.